Today is our program on Prudential standards and living wills under the Dodd-Frank Act. Our particular focus will be on the applicability to foreign banking organizations, and my colleagues, who I'll introduce in a moment, will really carry the major load and have most of the knowledge to convey. Just a minor housekeeping item, since we are both live with people in the room and on the on the web. The web participants should have a chat feature within the WebEx tool that will allow you to ask questions. We may not be able to get to everyone's question. Don't be deterred. Please send your question through anyway. And we can certainly speak offline after the program, or you could, of course, contact any of us directly. Contact information is in the materials that you should all have. Lines will be muted on your end, but if you need assistance, just press *0, and a coordinator from our staff will be happy to jump on. The event is being recorded, and we typically post it to the Arnold & Porter website, where it will be available to the public. Shortly after the program, we'll also post all the presentation materials that have been used. So again, thank you very much for coming, and why don't we start in. I'm Kevin Barnard. I'm a partner in the Banking and Financial Institutions practice based here in New York for A&P. To my immediate right is Dave Freeman, who heads our practice in that area. Dave is based in Washington, but thankfully is periodically in New York, and we hope comes more often to New York. I should say everyone's bio and detailed information is in the material, so we won't go through that in any detail. To Dave's immediate right is Evan Hollander, who's a partner in our bankruptcy and restructuring practice. We are in a period, and this is a topic where the need for people with Evan's skills may become more evident as time plays out. So we welcome Evan to our group. And Kathy Scott, to Evan's immediate right, is also in our banking and financial institutions practice, has had a career both as a regulator and in private practice, has had a particular focus on work for foreign banking organizations, and I think among all of us, at least on the A&P team today, is the person who has actually been involved in resolving and liquidating one or more U.S. offices of a foreign banking organization. So a skill that we hope no one on the call today has any need to call on anytime soon, but it is there if needed. What I'm going to do is just give some introductory remarks as to how the Prudential standards and living will requirement came in. We're still in a period where, as with so much of the Dodd-Frank rulemaking, final rules are still not in place in most cases. The two particular sections of Dodd-Frank that we're most concerned with started out clearly with a domestic focus, and Federal Reserve and the other agencies, but the Fed is in the lead here, came out with a proposed rulemaking in January of 2012, which really focuses on the domestic organizations. They specifically mentioned that because of issues that needed additional review and analysis, the applicability of enhanced Prudential standards and resolution plan or living will requirements for foreign banking organizations would be dealt with in a further rulemaking, which then did emerge several months later. Both the January 2012 rulemaking and the subsequent rulemaking for foreign banking organizations have not been finalized. And in fact, the key provisions applicable to foreign banking organizations are still open for comment. The comment period has been extended twice now. Very briefly, the context from which a lot of this emerged, of course, was the turmoil of 2008 2008 and 2009, a sense that large, complex organizations, many of them traditional banking organizations, but certainly not all of them, presented a risk to the financial system, both in the U.S. and globally, which was either poorly understood or at least poorly tracked and regulated by the existing supervisory tools that were in place, and that something else was needed. Like so much of the Dodd-Frank Act, some very broad requirements were put in place, but a great deal was left to regulatory rulemaking and adoption. Again, that's still the period that we're largely in. One, focusing just again for the moment on the domestic organizations, but this is largely carried forward, as you'll hear, to the foreign banking organizations. Federal Reserve was mandated to issue rules for enhanced standards in a number of areas, and I won't go through slides in any particular detail, but they hit all of the key areas involving capital, liquidity, risk management, including in some cases establishment of risk committees within an organization with a particular mandate and charge, credit limits, particularly for large counterparties, large organizations dealing with other large organizations, stress test requirements, which is the one area where rules have been advanced and finalized, and in certain cases, limits on debt to equity ratios and funding. The general, I think, rubric that this fits under is an attempt to deal with organizations that were thought to be so important to the financial system that if they experienced the kind of turmoil and stress that was seen in the 2008-2009 period, we could once again have a crisis mode environment calling on extraordinary measures from the government and ultimately extraordinary support from taxpayers. In the midst of the debate on these issues, which of course are not limited to the U.S., it was recognized that in the U.S. we have both the large U.S. banks that operate globally and large foreign banking organizations, and in many cases non-bank financial institutions that operate on a global platform and are key participants in the markets in any number of jurisdictions, and certainly almost all participate actively in the U.S. In July of 2011, the Financial Stability Board, one of the several sort of College of Cardinals organizations of principal supervisors from the developed countries, issued a consultative paper. So this preceded the Fed-driven rulemaking that came out in January of 2012, and a number of the provisions in that, or suggestions in that consultative paper, came to be picked up in the Fed release, and then subsequently in the more focused foreign bank release, including the requirement for specific resolution plans for the organizations, which you'll hear described, the more systemically important organizations that were the focus of these rulemakings. Rather than go in any real detail through slides that are in the book, they are picked up in one way or another in David, Evan, or Kathy's presentation. And since we want to focus particularly on foreign banking organizations, I think the best way to get into some of the details of who's covered by these proposed rules at an operational level, what might they mean to deal with some of these requirements, I think is probably best handled as we hand off from one to another. I think in the order that the materials appear in the book, probably Kathy should take it from here, and then we'll just follow the order that we have in the materials. Kathy?
Can I borrow the clicker? Thanks, Kevin. As you said, I'm going to focus on the proposed enhanced standards and early remediation, or proposed standards for the foreign banks in the U.S. And it's in many ways similar to what is in the proposals for the domestic banks. In the preamble to the proposed rule, the Fed, though, makes the point that even though the proposals for the domestic banks are still outstanding, to the extent that there are some differences in the foreign bank proposed prudential standards, that people should not get the notion that that's what they're thinking about doing for the domestics. So sort of everything is sort of still a little up in the air. But the notice of proposed rulemaking was published on December 28th, and the original deadline for comments was March 31st. It's now been extended to April 30th, and banks and others are strongly urged to comment. They actually posed 103 questions for commenters to consider, but obviously you're not just limited to the 103. They want to know specifically what your thoughts are on these particular proposals. And then so under the foreign bank context, which entities are covered by them? It's applicable to foreign banking organizations with at least $10 billion in global consolidated assets that also maintain a branch or agency in a state in the U.S., control a commercial lending company organized under state law, or control a U.S. bank, or any company of which the foreign bank is a subsidiary. So similar to the domestic, except for one big exception, which I'll discuss first, the enhanced prudential standards include a lot of the same things, touch on the same issues as the domestic standards. Increased capital, leverage, liquidity requirements, single counterparty credit limits, risk management and risk committee, stress tests, and are similar, not exactly the same, but similar to the domestic. The biggest change, or the biggest proposal, is this intermediate holding company idea. The foreign banking organizations that have 50 billion or more in global consolidated assets and U.S. Consolidated assets of at least 10 billion that are booked in U.S. subs would be required to form a U.S. intermediate holding company to hold those assets. The stated purpose of the proposal is to implement a consistent supervisory program across U.S. subsidiaries of FBOs. That's what the Fed has said, and it's in the proposal. In calculating the 10 billion, though, you would exclude the assets of the U.S. branches and agencies, and also U.S. subs held under Section 2H2 of the Bank Holding Company Act. And sort of as a brief summary of what that refers to, 2H2 companies are companies that the foreign banks can sometimes do many things outside the United States that a U.S. bank holding company cannot do. And in the United States, a foreign bank can only do in its non-banking activities what a bank holding company can do, or a financial holding company if you qualify. 2H2 companies are companies that they own, the foreign bank may own elsewhere in the United States, elsewhere in the world, that have a U.S. subsidiary presence, engage in an activity that normally they would not be able to engage. Those are excluded from the calculation. These are not actively managed by the bank; they're more just investments. Also, the Fed has indicated that a U.S. IHC could help facilitate a resolution or restructuring by providing one top-tier U.S. legal entity to be resolved or restructured, and it would also reduce, in their view, the ability of FBOs to minimize or avoid enhanced prudential requirements by trying to restructure their operations in ways that would reduce, not reduce their U.S. risk profile. And also, as with the proposed domestic prudential standards, the triggers include, for early remediation, low regulatory capital ratios, market-based indicators, and risk management weaknesses. And again, the Fed's view is the triggers are broadly consistent with those proposed for U.S. bank holding companies. And you have the same 4 levels of escalation. First, you have the heightened supervisory review, then initial remediation, recovery, and then recommended resolution, which can be a nice euphemism for foreign banks, which would mean they can actually, the Fed would actually withdraw its, terminate the non-U.S. banks' ability to operate in the United States. And also for those who have read other parts of Dodd-Frank, there's actually another provision in Dodd-Frank that was added to the International Banking Act that does allow the Fed to, under systemic risk determination, also try to terminate the operations in the United States of the foreign bank. Now, the imposition of the early remediation measures are just at the discretion of the Fed for FBOs that have less than $50 billion in total U.S. assets, but they become mandatory once the assets reach $50 billion. And so what we have now, the next set of slides, sort of slice and dice the proposal according to how large the FBO is. So starting off with FBOs with at least $10 billion in global assets, they're going to be required to, if they're publicly traded, certify that they maintain a U.S. risk committee that has at least one member with risk management expertise, commensurate with, among other criteria, the risk profile and complexity of the actual the combined U.S. operations of that particular foreign bank. Also, it would need to be subject to a home country stress testing regime that's broadly consistent with the FRB's own stress testing requirements for U.S. bank holding companies. Otherwise, the foreign bank will be subject to additional requirements to help ensure the capital adequacy of their U.S. operations. There's sort of, I think, to the extent, and this is my own editorializing, the Fed is trying to make the foreign bank operations look as much as possible in the United States like a regular U.S. bank holding company in its operations. In determining the number and determining whether it's 10 billion, 50 billion, whatever, what they're looking at is they look at the 7 Qs that are filed and the 4 recent consecutive quarters, looking backwards. If it's 50 billion, 10 billion, whatever, you've met whatever the threshold is. You only come out of that requirement if you then have another 4 subsequent consecutive quarters that show you at less whatever the trigger is. So FBOs with at least 50 billion in global assets, but less than 50 billion in the U.S., that's sort of the next level up. And they need to comply with the requirements for FBOs with at least 10 billion of total global consolidated assets. They have to certify to the Fed that they meet the capital adequacy standards established by the home country for consolidated supervision, and that those standards are consistent with the Basel Capital Accords. And when they say Basel Capital Accords, they mean the most recent version of the Capital Accords, which is referred to colloquially as Basel III. They also need to annually report to the FRB the results of an internal liquidity stress test, either consolidated basis or just combined U.S. operations, again, under the home country stress testing regime, and that stress testing regime has to be broadly consistent with the U.S. testing. And again, they can be subject to the discretionary early remediation requirements if deemed necessary by the FRB. Also, they have to limit their aggregate net credit exposure to a single unaffiliated counterparty to 25% of the regulatory capital of the FBO, or if it has an intermediate holding company, the intermediate holding company. And that limit becomes stricter the higher the amount of the total global or U.S. consolidated assets. They're proposing that the limits would still be applicable to non-U.S. sovereign governments, except the FBO's own home country sovereign, and also applicable to U.S. state and local governments, but not the U.S. federal government. And then, as I said, the higher they go, the stricter they become. They're proposing that FBOs that have total global consolidated assets of at least 500 billion, or NHACs with assets of at least 500 billion, would be subject to stricter loan-to-one borrower limits of between 10 to 25%. The proposal actually has a little X in brackets. They have not yet put a percentage in. They want to get comments on that particular aspect of it. So the next level up is you have 50 billion in global assets and at least 10 billion in U.S. assets. And as I said, they exclude the assets of the branches or agencies, and they also exclude these 2H2 companies. So at that level, that's when the U.S. IHC subsidiary requirement comes into play. Except for 2H2 companies, you do not have to move those investments into there. also, for those foreign banks that have qualified as financial holding companies, they do not need to move their merchant banking investments, again, another version of a passive type investment, into the IHC. The FRB is proposing to apply the U.S. bank holding company risk-based capital and leverage requirements to the IHC, just like a U.S. bank holding company. As you said, the theme continues. And it's regardless of whether or not the IHC holds a depository institution subsidiary. So you could have a situation where they have a branch, they only have their only direct banking operations or a branch and agency. They may have extensive non-bank activities. Those would go in the IHC if they reach the limit, and also they would end up having to comply with the requirements. FRB's supervisory letter 0101 is no longer effective. That was a requirement, that was a provision that allowed foreign banks that had U.S. top-tier holding companies that really were shells to still qualify as well capitalized if the institution as a whole met the home country standards. That is no longer applicable. Again, we're talking the 50 billion in global assets, U.S. assets of at least 10 billion. The U.S. IHC is going to be subject to the annual internal company-run stress requirements, stress testing of Dodd-Frank, same as the U.S. bank holding companies that have assets at least 10 billion. And then the next level up is FRBs with at least 50 billion in total assets and at least 50 billion in U.S. assets. At that point, you include the U.S. branches and agencies in this 50 billion, and then they also have to comply with all the other foregoing requirements. It's IHC. If the IHC has assets of more than 50 billion, it's going to be subject to the capital plan requirements and stress testing, again, run by the FRB, similar to a U.S. Bank holding company. And that would be in addition to any internal stress tests that are run semi-annually pursuant to Dodd-Frank. Also, the IHC and the branches and agencies are going to be subject to monthly liquidity stress tests and a 30-day liquidity buffer requirements that, again, applicable to U.S. bank holding companies. The IHCs would need to maintain these highly liquid and unencumbered assets for the entire 30 days. U.S. branches and agencies, they're proposing that after 14 days, you could actually maintain those assets at head office. And then moving along, whether or not publicly traded, they will have to have a U.S. chief risk officer in addition to a U.S. risk committee, with at least one member of the risk committee being independent. The proposal has quite extensive requirements for the U.S. risk officer, as well as the U.S. risk committee. They also will be subject to the non-discretionary early remediation requirements if the FRB determines that the FBO's U.S. operations are in financial distress. In addition, there are some other requirements, proposed requirements, that they have policies and procedures to monitor collateral, assets pledged as collateral in connection with transaction with U.S. counterparties, a debt-to-equity ratio of 15-1 if the FBO, if the Fed the Financial Stability Oversight Council determines that the particular institution needs to mitigate the risk, and also they need to have an independent management review function that would evaluate the liquidity requirements. And so the U.S. Risk Committee and the U.S. Risk Officer, will become a very, to the extent it's not already an important role, its role is much augmented by the proposal. The FRB's proposed a long implementation period, again, similar to what they're sort of looking at for the domestics. The proposed effective date generally is July 1st, 2015. For those FBOs that meet the regulations' various thresholds that I've talked about, 50 billion, 10 billion, et cetera, as of July 1st, 2014, including the requirement to form an IHC, that's when it would become effective on July 1st, 2015. Those reaching thresholds after 2014, generally, again, subject to certain exceptions, will have a year after that to conform to the requirements. So that's sort of a broad overview of the proposed Prudential standards for foreign banks. And so I will turn it over to Dave and Evan to talk about resolution issues.
Thank you, Kathy. The topic Kathy was talking about, resolution, the Prudential standards, kind of plays in to the other half of what I'm going to talk about and Evan's going to talk about, which is resolution planning. Kathy's focus primarily is how to prevent bad things from happening by the way in which you do liquidity planning and capital planning and stress test and develop scenarios to make sure the bad things don't happen. But it's really kind of forward-looking as a preventative measure and to some extent to remediate. What Evan and I are going to talk about is resolution plan, which is if everything goes south, having a strategy, a plan to deal with the winding up essentially of the company. So it is a prepackaged resolution of the company. If for those of you who are familiar with the way they do this in the United Kingdom, they have a similar set of rules but with a slightly different focus. In the UK, under their plans, there's a recovery plan that the institutions prepare and work through and get approved, and that is designed, if bad things happen, to help the institution right itself. But there's also a resolution plan, which is more prepared by the regulators, and that is what happens if everything goes bad and they have to resolve the institution. So it's a similar set of topics with a slightly different focus in the way in which it's done. Now, the rules here are actually in final. They're 12 CFR 360.10, which is the rule for resolution planning for insured banks, and that is an FDIC rule. And 12 CFR 381, which is jointly adopted essentially by the Fed and the FDIC, and that is for holding companies of these institutions, non-banks that have been designated as systemically important, and also for non-U.S. banks in respect of their U.S. operations and activities. Now, for those of you who are CFR junkies, you wonder why a Fed rule's in Part 381 with the FDIC rules. And the reason is, for these types of institutions, if they blow up, the FDIC under the new Dodd-Frank regime is the entity that resolves it under kind of a supercharged version of the FDI Act that was enacted by Dodd-Frank Act. So that's why these rules are sort of joint Fed FDIC rules. And the overall focus of the rules is designed to say, how could we do this without how could we do it in the normal process of resolution as opposed to using these super FDIC powers? What I'm going to talk about is the task of preparing the plan, what steps a company and its advisors should be working through as a process to get the plan. And Evan's going to talk more about the details of what's got to be in the plan and some of the technical aspects of the plan and the planning process. So it looks like we're talking about the same thing, but it's really a different aspect of it. Now, this first slide here I've got, this is just sort of an overview of the different things we're going to go through. As a task, institutions should be creating teams and defining for them the various tasks that they've got within each team. There's a requirement of corporate oversight from the top and approval of the process and the plan. That's built into the rule. That's a governance requirement. A big part of the task is mapping your entities and your activities and all the things that attach to them and how they interrelate. So a large part of the task is mapping everything out. A next part of the task is gathering all the key documents. This is a very data-intensive thing, so getting all the relevant documents that you'll need in the process. You'll probably get a first set, then you realize you need more, so you'll be going back to the well several different times with your teams. Another important task is working with the regulators. This is key. It's interactive. The rule says only so much, and a lot of this is going to be worked out as you go, both in the initial year of the planning process and every year thereafter. There'll be a lot of interaction between the bank and its regulator. Now, number 6 slide, we won't give a lot of speaking to a decision whether to give a tailored plan or a full plan. You need to make that decision by tomorrow, so hopefully you've made it, and if you want to file a tailored plan, you've put in your request to the regulators that you'd be allowed to do a tailored plan. Then really sort of the meat of what you're doing is developing the resolution approach and the strategy and the plan. You'll be preparing a written summary portion that is public. Good examples of those are on the Fed website for those institutions that had to file last year. They've got their plans up. It's kind of a brochure type of treatment. It doesn't give you a lot of detail, but it kind of gives you a flavor. And then in addition, there's a non-public detailed written resolution plan. So if the public portion might be 15 pages, the non-public portion is going to be hundreds of pages and lots of information. That would essentially be proprietary information that you would have in developing this plan. You want to also designate a response team and keep that updated. So if the crisis does hit, there's a team in place, like to deal with any other type of crisis that might beset you, that knows what their roles are, what they need to do when the bad thing happens, and all of that be assigned to them. And then finally, there's a requirement of an annual review, and we'll talk a little bit about that. You annually review and update the plan and resubmit it to the regulators, and they give you further comments. Okay. So getting into our first the tasks here, it's important that you designate very specifically the people who are responsible for the project early on. This is a very large task, and everyone's got to have a very specific assigned role. So, get the people, get the team set up. You will probably be needing outside service providers, consulting firms, accounting firms, law firms. Investment banks are required for a part of this, or other valuation experts who can help you with certain aspects of the plan that we'll get to. So you want to go ahead and do that early on, because that's going to be a large interaction there that'll take a lot of time. You want to prepare a time and responsibility schedule, just like in a deal, so that people know, okay, I've got to get this done on this period of time, here's the output, here's who I have to get it to, so that you stay on schedule. There's just a few months left for the medium-sized institutions, and then the rest of the group have till the end of this year, but that's not a lot of time to get this done. Now, as part of this process of creating teams and defining tasks, education of all the participants in this is important. You need to do it early, so that they understand why you're doing this and what they have to do, and so that they really understand the magnitude of the process. You want to get buy-in at the front end from the senior-most people, so there's support, that there's the tone at the top. This is important. We need to get it done, and we need to get it on time. You need it from all the managers, from the top to the middle to the bottom, so that all the worker bees who are going to need to get this done understand this is a priority, and understand the significance, and understand exactly what it is they're supposed to be doing. They're not kind of wandering around, letting dates slip, and not really figuring out what they're supposed to do. So you want that early on. It's a big task, and that's part of the message. It's going to be data intensive, so there will be a lot of information that will need to be gathered up, collated, analyzed, and put in a way that you can use it in building your plan and explaining the plan to the regulators, because they will do a lot of review and they'll want access to the data that supports the plan. And you need that in a format that can be continually updated, because as time passes, information changes. So it's not a static plan. So you need a data process that can address that. And the gathering of the data, in some sense, and the developing a plan is like peeling an onion. You get the first level and you say, okay, here's the big picture. And then as you zero in, you've got this amount of data, and you realize there's something more you need to know, or you need it in a different way. So as you get more and more detailed in the plan, you'll realize there's more things you have to decide. There's more data you're going to have to go back to your business units or go back to your investment bank or different people to build the plan. So be prepared for kind of an iterative process. And you do need to start with a process here. And that is, because it's such a big task, going to require a lot of different people, it needs to be coordinated, and you need to think of it not as just a piece of paper that's going to spit out at the end or a document, but there's a whole planning process that needs to be coordinated and done very carefully to keep it, kind of consistent with what you need to do in timing and content. One of the important aspects of the rules of both the FDIC and the Fed is there needs to be corporate oversight from the very top and approval of the process. So early on, there needs to be a meeting with senior management and the board of directors and the task leaders to explain the project and what the regulatory requirements are, so the board understands that. There should be a board resolution that directs the teams, assigns a team and directs them to develop the plan, assigns senior officers to be responsible. So there's individuals, named people tasked with this, and kind of a chain of reporting, and empower them to develop the plan and approve the plan, approve the meeting with the regulators and the filing of the plan with the regulators. So the board needs to be continually updated, or committee of the board, in this process and kept in the loop, and they need to understand what's going on and bless it. There should be a board committee to oversee it and get the periodic reports that's kept updated, and whatever concerns, questions, they need to provide that feedback to management. And then when the final plan is ready, or at least there'll be a final plan every year, but each time that's done, the board should meet to approve that plan so that the regulator doesn't have some question that, this is management, but the board isn't on board for it. Okay. Then we get to the task of mapping. It's often said that when a company is operating, businesses operate as business lines while they're healthy, but when the company fails and goes into bankruptcy or receivership, it's the legal entities that matter, because that defines the rights of the creditors and the counterparties. And so, as the business is operating, you're thinking of, the business groups or units, but underneath there are legal entities that have their rights and obligations of creditors are different. So you have to think about those two different things. And part of the mapping process is figuring out how they fit together and how those units actually work. So a big part of this task is preparing a map of the whole thing. You need to gather a lot of information. There's the overall group. You want a map of the group as a whole. So you're looking at financial statements for the group as a whole and the bank. You want the consolidating schedules for the larger entities. You want a very detailed organizational chart, sticks and boxes, that shows the legal entities and how they fit together, who owns what, and how that relates to the business lines and operating units that are not themselves legal entities. You want to gather up all of the things that kind of interrelate these companies: expense sharing agreements, tax sharing agreements, space sharing agreements, the way in which overhead and allocation, similar agreements and protocols work. You want a detailed line of business organization chart showing the functional business units and indicating which are core business lines or critical lines of business, which is a topic Evan will get to, and the reporting lines up within the organization. And you want to, that line of business org chart you should relate to the legal entity org chart. You need a main office address. You need a list of the board and committees, a list of the regulators, the accounting firm, contact person there. You want information on the treasury desk and liquidity cash management function for the group, because at the first sign of trouble, it's managing liquidity that's probably the most important thing to deal with. And so that has to be mapped out and looped in. Information on netting agreements. If you engage in swaps, futures, options, other derivatives, that needs some careful attention. So that's kind of a yes, no. Are you in that? How big? Which units? That sort of thing. And then are there central servicing arrangements? Is an entity that provides services across the company? What is that entity? What are those arrangements? Because if that entity itself gets into trouble, it may be unable to service everything else. So this little back office-y thing, if it goes bad, it could bring down a lot of things. And so this kind of behind the scenes entity needs a lot of attention. Are there central funding arrangements? Is there a commercial paper program? You need to loop into that and figure that out. And what happens if that entity and its unit goes bad? Are there inter-affiliate netting arrangements? So you need to figure all those things out, gather the information, get the documents, and map them out. And for non-U.S. banks, you need a separate map for the U.S. operations. And so you're looking at the branch and their financial statements, the U.S. broker-dealer and its financial statements. For the bigger units, the broker-dealer, you want the FINRA membership agreement, Form BD, the supervisory manual. They probably have a chaperoning agreement on 15A6. You want to see that, how that works, and how it interrelates to the home office. Record-keeping back office, middle office, services agreements, clearing agreements, everything that may be needed to keep the U.S. entity functional for a period of time as it's resolved. You need to smoke all those things out and map them. And you want, for the foreign organization, a detailed org chart for the legal entities within the U.S. If they're organized under U.S. law, or if they have a place of business in the U.S., or if they're licensed and regulated by U.S. regulators. And then for many institutions that are overseas, they have a U.S. commercial paper program. That needs to factor into the U.S. group map. And then for the individual legal entities, this is, as you have the big org chart, there's little organizations within that. You got to map each of those out to some degree. You want the name. There's something called a legal entity identifier, which is how the regulators think of it. A CRD number or license number. You need the type of entity. Is it a corporation, LLC, year, where it's organized, address, offices, name of the landlord, etc. So there's all this information in detail that you're going to need for each of the legal entities within that as part of your mapping process. And then, as maybe in parallel actually to doing the map, but you need to gather key documents. These may not be sequential. They may be split up to different teams and that will then interact and work in these background tasks to develop the plan. You want to gather all the key documents, and as you gather them, you may figure out there's more that you need. So examples are financial statements for the group and the individual entity, focus reports for the broker, Form BD, the membership agreement, netting agreements, ISDA, leases, subleases, equipment leases, any kind of inter-affiliate agreements or protocols for space sharing, expense allocation, tax sharing, all those kinds of things, pension plans for your employees, retirement plan documents, funding information, how data and systems work. What are all the documents for getting those services and maintaining them? Because if you lose your data, or if you lose your access to data, that could be a crisis. So you need to know what is the infrastructure and get all the documents for that. Clearing agreements are key. Employment contracts of key personnel. What are their rights? Borrowing agreements among the entities or across to obtain financing. Agreements with correspondent banks. Any sort of clearinghouse, clearing agency, payment system. You want the membership agreement and rules for those things, because those may get cut off in a crisis. Master repo agreements, securities borrowing, lending agreements, any sort of securitization structures or vehicles. You want the documents for that. Or if you participate as investment or use for securitization. Joint ventures, deposit brokers, secured borrowing agreements, data provider agreements, anything of that nature, any of the key documents. You want to gather them up, see what they say, how they define rights, what would happen if there's some kind of default within the organization to your BA, what are you going to have to post collateral? Do you just get cut off? All those sorts of things. You need to figure it out, gather the documents. You should maintain the key documents as a document pack, so that if the resolution folks, either your resolution team or the regulators, need to come in and resolve the institutions, they're not scurrying around 10,000 offices in 50 states to figure out where these documents are. You want them kept. You want to keep that pack of key documents updated. It might be on a data stick, it might be hard copy, it might be both, but you want to have a gathered set that they can grab and use. In a way, it's similar to diligencing a deal. Think of it as sort of a deal room, a data room. If you're going in to resolve the institution, it's like a huge deal. You're selling the company in pieces, so people need all the relevant documents, and they need to get them fast, not, we'll get them for you in a month. The company will be gone in a month. You want to look for in these documents, you want to be looking for events of default. What are the remedies and consequences of a default? Are there collateralization, cross-collateralization provisions in these different agreements? What guarantees, indemnities are there across the institution or by other entities in these agreements? And any other contractual interdependencies among your different mapped entities. So if this one goes bad and this one guarantees it, this one's got a problem too. And you need to figure out all those creditor rights or contractual relationships that are going to kick in based on your contracts. You need to work with the regulators, because at the end of the day, it's the FDIC and the Fed who are going to be implementing this plan, or at least riding shotgun on your remaining staff who will help them implement the plan. And they have ultimate sign-off authority on approving the plan. So if you're a foreign banking organization, you should start by talking to your home country regulator. They should be aware that this is going on in the U.S. There are a few countries that have these similar things, like the United Kingdom. As Kevin mentioned, there's sort of an international coordinating, so the international version of the FSOC called the Financial Stability Board. It has representatives from every regulator around the world, so they've been doing a similar task. It's being pushed out to their members' organizations. So your home country regulators will be aware of this, but most countries have not really gotten into it. But you should start, if you're a foreign organization, by talking to your home country regulator about what you're doing here. Then you should meet with the Fed and/or FDIC to get their initial guidance. They have some views you want to know early on. Touch base with them, let them know you're working on it, and get whatever feedback or instructions they've got. That's something to do at the outset, and keep that line of communication open. If you're submitting a tailored plan by tomorrow, request for tailored plan, they have to tell you within 90 days whether they're going to let you file a tailored plan. Now, the term tailored plan is a little bit of a misnomer because they're all tailored plans. None of these are off the shelf. This is not a packaged product. It's all going to be mapped and designed for your organization. The tailored plan is kind of a smaller plan for institutions who meet certain criteria that leaves off some of the details for the foreign entities and some of the other entities. But they're all tailored plans in a sense, but the formal it's a tailored plan thing, you'll get a response back if you request as to whether you're allowed to do it. You want to submit some initial drafts to get some feedback from them. The Fed and the FDIC will give you feedback. They will press and test your assumptions, your data. They will push to see how real it is. And they may use that process to point out flaws. The only way to correct those flaws is to change the structure of your organization now. Change the way it's funded. Change the way some of the business lines map to legal entities. Change the way in which certain assets map to liabilities. So that in a bankruptcy, the plan you got actually works. So they may use this process of commenting on your plan to force you to change how you run your business now. Okay? So that's something to be prepared for. So you get their feedback, you revise the drafts and resubmit. That keeps going round and round till they accept it. Okay? So expect a lot of comment and feedback no matter how good a job you do. If you don't do a very good job, you'll also have a very angry regulator, and that's not a good way to start. So you want them to have confidence that you're doing a very good effort and you really have put in everything you can. And then you'll be submitting this. Well, if there's any material changes that would affect the plan, you have to notify them within 45 days of that change, unless it's right before you have to submit a new annual plan anyway, and then you just go to the annual plan. Then annually, on the anniversary of the first plan you submitted, you have to submit a new plan every year. I think Evan will go into more detail on the tailored plan, but this is sort of an alternative. I think it's primarily of interest for foreign banks and some certain other types of companies that lets them do a less extensive plan about parts of their organization on the theory that a lot of it's going to be covered by their bank plan. And that's for institutions that have a large banking entity that will be resolved by the bank regulator. Okay, in developing the plan, you want to gather and refine the information, the maps, and all the interdependencies and exposures and risks. That's a big part of the task, is figuring all the interconnections. Identify the critical functions and business lines, the assets and risk, and how to address them in a resolution. So the plan is getting you to this place as you think through all those things. And then there are a variety of alternatives. There's not so many things you can do a resolution. There's no sort of magical helicopter that's going to come in and save you. You're going to sell it, you're going to wind it down, liquidate it, or you're going to bridge it in some sort of thing that eventually gets sold. You need to consider creditor rights and the strategic alternatives in the treatment in bankruptcy. You need to know the bankruptcy process because the court may grab a hold of this thing before the FDIC gets it. You need to know what the rights of the creditors are, what the rights would be if the FDIC were to resolve it, so that the plan will actually work, under the supervision of the resolution that will occur. And you may need, in order for that actually to work, you may need to simplify the structure. You may need to align the assets and liabilities. You may need to change the funding and methods to address what would happen if a court got a hold of the resolution. You need to look at the alternatives that you've got. What are the weaknesses and what are the things that could block you from implementing those, and figure out how to address it. Got to figure out how to accomplish the plan. Will it really work? So, strategize as if you're actually going to have to do it, soon. How you'd price the things you're selling and how you'd fund them. That's where you're going to have to involve probably investment bankers and the like to help you with that aspect of it, or those aspects of it. And then it may be that only a piece of the company gets into trouble and that gets resolved. What happens? What is the impact on the rest of your company? I mean, there's reputational, there's funding, there may be other linkages. You need to figure those things out as part of the planning process. Okay, now there will be two pieces to it. There's a public document that describes the key elements for the resolution, and changes since the previous year to the plan. There'll be a description of what you changed, not the first year, but the next year and the following years. You'll describe what changes you put in place and why. And also, as you look at the plan every year, you think, we're going to make some changes to how we operate to help us address some of these issues. You have to describe that also. Now, if you're interested, there are some public portions been filed for the larger organizations, and you may get a flavor of it. Since it's a first-year public plan, it doesn't describe the change process. So hopefully, after July, you'll see the change process described in it. But it's very high level. It's got names of entities and business lines and kind of high-level information about different activities, what payment systems are involved. The rule has a list of what has to be in there. Now, this is public document. It's going to be currently they're posted to the internet. I don't know if they'll keep doing that going forward, but they probably will. But in any event, you have to assume anything in there is open, fair game for anyone in the world to look at. So be careful what you say in there and what you put in there. Now that's a short document. The non-public is a more detailed written resolution plan. This is going to be hundreds of pages long, lots of data, lots of stuff. Now, the fact that it's designated as non-public in the rule doesn't mean that someone can't try to get it under FOIA or through a lawsuit or whatever. So you have to be careful about what is designated as confidential and be able to support it under the criteria of the Freedom of Information Act. It's information not available from another source. It could be damaging to you and your business if your competitors or others got a hold of it. You need to build a process around protecting the confidentiality of this, because there may be a challenge as someone tries to get a hold of your plan and you don't want them to have it. As we said earlier, you got to have the board involved and senior management. It's going to be an iterative process. You're going to go back round and round and round through rounds of gathering data and enhancing and improving the plan. The first year, you just have kind of a normal economic condition where you're the only company in trouble. For the second and subsequent years, you have to have 3 economic scenarios that you have to map out. One of them is the normal, you're the only one in trouble. The other one is, it's kind of a recession and some people are in trouble. And the third is, all hell is broken loose in the markets. It's like 2008 all over again. How are you going to resolve that in the kind of crisis context? You also have to assume there'll be no government support, not from the United States, not from the state of New York, not from your home country, not from any government. They will reject the plan if it has government support baked into it. The resolution plan the content is specified in the rule, but there's only so much detail a rule can give you. Evan's going to get into more detail on some of that content, but this slide here at the bottom is just kind of the headlines of what the topics are. So you need to address each of those topics. The rule and Evan have considerable more detail on each of those topics. You need to designate a resolution response team. These are the people who are going to implement the plan if the bad thing comes to occur. Have a team. You want to keep it updated as people come and go in the organization or get different responsibilities. Always that needs to be updated. Assign the task. There should be a work list so that they know, okay, we're in resolution mode. What do I do first day? What do I do first week? What do I do first month? Who do I call? All the different tasks should be laid out for them, so it's like a cookbook for them to go through. You want to have like a receiver pack and a buyer pack of documents and information, so that if you have to sell pieces of this company, you've got, essentially what amounts to a deal book to hand out, so that you can sell business lines and entities and implement it without having to spend 2 or 3 months figuring that out and preparing it. The receiver pack is so the FDIC or the Fed coming in to help with the resolution, they can have all the information they need. You may want to have essentially a diligence room on a stick for the entities you're going to have to sell, so that that's all ready to go. Get it set up. You don't have to spend weeks preparing it, because you won't have weeks, you'll have hours. The FDIC requires for the bank plan that it's 1 business day. And that's on the assumption it's a Friday, because they always close banks on a Friday, except when they don't. If it's not a Friday, you have 2 business days. But 2 business days when everyone's terrified is not very much time. So all of this stuff really should be prepared in advance, ready to go. So someone just plug in the stick, grab for the pack, you're ready to roll with your resolution plan. So that's key, to have all the details worked out. Now, there's an inter-year process and annual update process. 45 days of any material change, you have to tell the regulators. That doesn't mean you update the plan in 45 days. You got to tell them, oh, we just sold this unit, or we just bought this other unit, or we merged these units, or whatever is the big change that would affect your plan. You got to tell them, and then you have to address those changes in your next annual revised plan. Okay, what is the annual review? The annual process? There should be this continuous updating team. Maybe cut down from the first year's effort, but you're going to always be already updating the plan. There should be a working group, tasks, and timelines for each of the annual updates. You'll be looking at the existing plans and the maps and all the stuff you've created. Assess how well it would work. Once you've actually gone through the process, this piece really wasn't so good. Figure out how to make it better. What could block it? Figure out how to work around those things. Consider changes to the way you're structured, or the like that could affect the plan, and address them. You got to keep updating senior management, the board of the process, and consult with your regulators. They will have some input. Now, what I expect is going to happen is the first year, the Fed will have this level of expectations because it's new, and it's new to them, it's new to everybody. The next year, they're going to ratchet it up. Next year, and so in a few years, the details and content and sophistication of the plans will be, exponentially more elaborate than the first year, and you got to stay on top of that, and not just say, oh, we did that plan, let's just change the dates or the address of something. It's really a process. Okay, there's a document of the annual review process, summary of the material events and changes since the last plan, steps taken, and the reasons you changed the plan. Steps taken to improve its effectiveness in the last year and address the weaknesses. You got the updated plan itself. You got to take, after the first year, you got to take into case the baseline economy and adverse and severely adverse economic conditions. Make it harder to liquidate if there are no buyers out there. Make it harder to get your funding if no one's extending credit anymore. And the Fed every year is going to dictate what those conditions are. They'll have kind of a summary of what is the economic situation you're preparing for, and a description of the update process you've been through. And then on or before the anniversary of the initial plan submission, every year you'll be submitting this new plan, and they will then go through their whole feedback, and so you have to work with them. So I think between their feedback and you're preparing for the next year, this will always be going on. So this is kind of until someone chooses to repeal this part of the statute, this is something everyone's just going to have to live with, like an annual audit going forward. Now, I think I'll turn it over to Evan to take forward.
Thank you, David. All right, I'm going to drill down a little bit more on the contents and drafting a plan, but we've all been at this now for about an hour. It's pretty heavy stuff. So I'll have some mercy on you folks. I'll take it from about 30,000 feet. There is a lot of detail in the slides I put together. Hopefully a lot of that stuff is self-explanatory. If not, you should all feel free to give a ring to me or anybody on this team, who all of us are very well versed. Just kind of riffing off of some things that David mentioned before we get drilling down too far. One of the things was, to worry, you have a large confidential portion of the plan, the real meat of your plan, and to be concerned that, notwithstanding that it's filed confidentially, you have to think about ways to protect it if people make a FOIA request and the like. One thing to keep in mind, though, these plans, they make it clear in the final rule that they're not binding on the courts, they're not binding on the person who's designated to actually resolve the corporation, and there's no private right of action. So hopefully that can help you in defending against things like that. Now, some folks, a lot of us lawyers are kind of naturally cynical. That doesn't mean that this is a make-work process, that it's not binding. I think that's more in the reality that when you actually get into a situation, the fact that you, when looking forward, thought this was the best way to resolve the enterprise, you're not going to be bound to that. That's ridiculous. You're going to do what's really needed to be done at the time. And again, it isn't a make-work process. A lot of the literature you might have read on the stuff has a lot of debate as whether this is a top-down process or whether it's a bottom-up process. I think probably at the end of the day, you have to start with some top-down process, but you'll see as we go through the slides that the information, again, it's not just generate a bunch of information. The information, I really think this is a well-crafted statute, is designed to make you think and challenge your strategic plan. So it is an iterative process. There's going to be a lot of dialogue internally between your initial strategic plan and the information that you generate back. That how does that really work with your plan? And just one other top line item before we get into it. It's very much set up to be a developing process. I mean, the fact that the plans, that you may look at a plan now and it's, geez, it's not really going to resolve the companies, is it? Over time, I think it will. We're in the first stage of development. The regulators are in a learning process. The people putting it together in a learning process. And in fact, even built into the rules, there's some relief given to the first year's plan. For example, going forward, when you put together your plan, and it's very well thought out, you have to say, well, if I have to resolve my enterprise now, what's the economic environment going to be like? Does that really depend upon? And so going forward, I think it's the Federal Reserve Board is going to promulgate various economic scenarios. A base case scenario, which is a reasonable economy, and your company has an issue. A adverse economic environment and a severely adverse economic environment, which is more of kind of a systemic problems. But for the first year, you're going to produce your plan just on the baseline scenario. So the second time, as you get further into it, you'll have more complexity in your subsequent plans. I think a lot of this stuff has been touched upon in the other folks' presentations, so I'll just kind of highlight it again. It's basically all bank holding companies, wherever located, with over 50 billion or more of total assets or operations in the U.S. are going to have to file a resolution plan here. Also, non-financial companies that are designated by the Financial Stability Oversight Council for enhanced supervision. And the plans are going to be submitted to the FDIC, to the Federal Reserve Board, and to the Financial Stability Oversight Council. Again, I think it's been mentioned before, when they were thinking of putting together the rules, they had to confront, the wave of filing companies, and they finally decided the way to do it was to make for staggered filing. The big guys have already filed their plan, the tier one guys. Those are folks with over 250 billion in total non-bank assets. They filed last July. The next tier are folks with over 100 billion of non-bank assets, or foreign companies with U.S. assets over 100 billion. Their deadline is approaching fast. Those tier two, that's July of this year. And then the third tier, which is enterprises with over 50 billion of total non-bank assets, or larger institutions that have over 50 of U.S. Non-bank assets up to 100. They will be filing by the end of the year. So what happens if you're subsequently you're a 40 billion enterprise this year, and 2 years down the road, or sometime next year, or sometime in the future, your assets rise above the level, the threshold that, congratulations, now you're a filing entity. Well, the rule deals with that too. It basically gives you till the July 1st of the following year to put together your first initial resolution plan, so long as that, that July 1st is over 270 days away. So you get really the longer of 270 days, or the following July 1st. And you can kind of fall in and out of being a reporting company, depending on your asset size, or if you're otherwise designated by the Financial Stability Oversight Commission. When must subsequent plans be filed? I think we touched on that too. They're going to be filed annually. Updates of your plan, and again, it's going to be iterative. After your initial plan, obviously it's going to be more complicated, because now you've got to, among other things, address 3 scenarios, not just one economic scenario. You're also, initially, I think they were contemplating requiring folks to file subsequent plans when there was a material change to their enterprise. I think there was ultimately a recognition of just how difficult putting these things together are, and so therefore what the final rule says is, when you have that material event, you need to provide notice to the appropriate regulators, and then presumably, if it's significant enough, they may ask you to put together an updated plan, or they may just put a pin in it and let you file again in the subsequent year. But it's not ultimately not required to file. Assumptions that should be used when putting together your plan. Like I said, mentioned the 3 economic scenarios. They're going to be provided annually by the Board of Governors of the Federal Reserve. You can download it off the website. It's pretty detailed in terms of domestic growth domestically, housing market, all different assumptions that hopefully your internal financial people will be very well suited to deal with. Baseline say, one, and I think David had already mentioned that, which is very difficult, I think, for some banks, particularly ones that have significantly governmental ownership. You can't assume any government support, any extraordinary government support in putting together your plan. Some key definitions. I think, maybe just to move it along, most of these, rapid and orderly resolution is a term of art, material financial distress, core business lines, critical operations, material entity. I think most of those terms you'll get close enough with your just kind of common sense of what they mean. The one that I'd want to point out, though, was not necessarily a common sense, is critical operations. And that's not really looking to you, the bank, although I presume if they will be critical to you too, that's really looking outward to, like, what operations do you manage or do you operate that the loss of which would pose a threat to the financial stability of the United States. So that's looking to the general economy. You have a settlement process or things such as that. There's going to be a public section and a confidential section. The public section is now posted on the website of the FDIC and the federal the other regulators. You can take a look at them. They're interesting in perhaps their lack of detail in a lot of ways as to what you're actually going to do. There's a lot of information of who's in charge and the like. They're about 20 pages, and all the large filers now have done that. If you want to look at Bank of America's or any of the other large banks. The contents of the plan, a public section. That's what we've been talking about. I think David pretty much hit all of these items. Have the names of the material entities, the description of your core business, the principal people who are running the operations, who's in charge of putting together the resolution plan, and the like. Contents of the plan, the confidential section. There's 8 basic categories of required information in a resolution plan. There are somewhat modified information requirements for foreign-based covered companies. The information is generally focused on the subsidiaries, branches, and agencies and critical operations and core business lines that are domiciled in the United States or conducted in material part within the United States. As you might imagine, that's what mostly concerns the U.S. regulators. But they also want to understand how your U.S. operations kind of map into your foreign operations and how your U.S. resolution plan will be integrated into an overall resolution plan for the enterprise, which is certainly an easier thing to do if your home country requires you to go through the process. A question of, what if you're in a situation where there really isn't a very detailed home company process? I guess that's something that's going to develop over years. As mentioned, there's a somewhat streamlined procedure for Tier 3 companies who are insured depository assets comprise 85% or more of their consolidated assets. And that's what's referred to as the tailored plan, and then you just focus on some of the more larger of your enterprises. But I don't really think it's not really that much easier from what I could tell looking at the rule. It's still an awful lot of, so it's a misnomer in that, as David said, all the plans are really tailored plans. It's also a misnomer because if you apply by tomorrow and get authorization to file your tailored plan, I'm not quite sure how much.
It's only a few less bits of information.
Right.
It's still a huge plan.
Yeah, it's still a lot of work. So folks really need to start thinking about this stuff. Okay, so the contents of the plan, there'll be an executive summary. The strategic analysis, which I really view as that's the top down, what is your plan to resolve your enterprise, and then the rest is kind of informational. And as we go through it, you'll see that there's so much really difficult stuff in the informational section that it really, if you're doing it right, it's really informing back and forth on your strategic plan and helping you rethink that. And so there'll be a lot of iteration. So it really is important that people start working on this soon, if you haven't already. The corporate governance issues relating to the resolution planning, I find that very interesting section because it really is designed, I think, to make this ingrained into the DNA of the organization. I'll point that out as we go through. The organizational structure and related information, management information systems, and that really is, again, how does management become aware of the critical issues, the interconnections and interdependencies of not only among the various business entities in your enterprise, but also looking outward to other institutions and what are the connections with other institutions. Supervisory and regulatory information, both at home and if you're a foreign bank, other regulators, and contact information not only for the person who's ultimately in charge for overseeing the resolution plan process, but also on your material entity level, who are the people at the various entities that are critical and in charge. The executive summary, we've pretty much explained that, but that basically sets out the key elements at a very, very high level of your strategic plan for a rapid and orderly resolution in the event of material financial distress. You also, going forward in your subsequent, after your initial plan, are supposed to disclose the changes to the company, the material changes to the company since the last resolution plan, and then actions taken since the last submission to improve the effectiveness of the plan. So again, that's built right in there, the evidence of the iterative process over time. The strategic analysis, you need to set out your key assumptions and supporting not only your key assumptions, but you have to have the underlying analysis that supports those assumptions. the range of actions to be taken to resolve the covered company, its material entities, critical operations, and core business lines. Very, very key, the funding and liquidity and capital needs when you're in resolution. I think maybe folks don't focus on that, and that's why perhaps it's helpful to have bankruptcy lawyers working in the process, because we are. You get into a resolution process, you have ongoing obligations you need to comply with. How are you going to do it? Where are you going to get the funding? What obligations you need to pay? I mean, the bankruptcy folks are used to talking about that type of stuff. I mean, the bottom line is, basically, you need to just have the sufficient funding for your operating expenses. Your institutional obligations will be put on hold. You don't need to worry about them. They'll get paid generally in order of priority. There's slight differences with financial institutions. There's exceptions to the automatic stay to let counterparties to financial transactions set off netting and the like. But it's basically very similar to any other enterprise in a proceeding. Even if you're not going to be resolved all your entities in a bankruptcy process, it's going to be fairly similar with some modifications: secured creditors first, unsecured creditors. Again, one of the big, some modification if you have a case of your retail banking operations, there'll be a priority for your depositors. For your broker-dealer operations, there's the customer priority, but it's very slight modifications. The other thing that I think is helpful of having the kind of bankruptcy lawyers involved in the process is that bankruptcy lawyers are very used to dealing with a large enterprise on an entity-by-entity basis and having different distribution, different distributions to creditors of different entities. And I think that on an ordinary, ongoing running a business, that people who run a business think more in terms of business lines than resolving on an entity-by-entity basis. Do you have a little more time? Or what
yeah, I'll give you a few minutes.
Maybe I just want to point out strategic analysis. One of the, I think, a very interesting thing, it's almost like the interview process. Tell me about your weaknesses. Part of the strategic plan is a description of the material weaknesses and impediments to achieving the plan. That's probably very difficult to do, except that when you look at the information requirements, I think when you get to when you start producing all the information, you're going to be hit with some pretty frank issues of difficulties of, you have a critical operation, but a lot of the personnel that deal with that operation are actually working for another entity in your enterprise. Some of the information systems are baked into another entity. A lot of stuff that's going to be very difficult to deal with, and perhaps in your initial resolution plan is going to be very stark, and as David suggested, you may be required, even with your initial plan or on a going forward basis, you might have to do some real organizational restructuring to kind of deal with those issues in subsequent resolution plans. Corporate, kind of really running short on time, so just point out again under the corporate governance related to the plan, I find that this is a very interesting section, quite frankly, because you have to put together a detailed explanation of how resolution planning is integrated into the corporate governance structure and process of your enterprise, the policies, procedures, and internal controls governing the preparation and approval of the plan, the identity of the people who are responsible for overseeing the development of the plan. I think this is really all geared to really ingraining this process into the DNA of the enterprise. You really have to think about it. It's not something that you leave to the lawyers with outside advisors to kind of put together so the regulators are satisfied. They really want to see how the board and the senior officers and directors of the company are involved in dealing with the issues involved with the resolution plan. Again, that's highlighted again. I think with the subsequent plans, that you have to disclose the description and nature and the extent of contingency planning since the last filing of the plan. and what you've done to reassess the viability of the plan. And then for informational, description of the risk measures used to report credit risk and exposure up the chain to the parties ultimately responsible for the health and maintenance of the organization. Let's see if there's anything else I should hit on. It's maybe just flipping through the organizational structure. Again, the last bullet point on this slide is slide 58. I've just jumped ahead to. Again, you're not only looking internally as to how to resolve your company, you're also looking externally. Who are your major counterparties? What's the interconnectivity with your major counterparties? What's the interdependence you have on your major counterparties? And that's also to help you understand, like, gee, if one of our if I don't have an internal problem, but it really my problems are triggered. Can my problem be triggered by a failure of one of my counterparties that I have a very extensive interconnections with? You sort of think about that and identify who those entities might be. I think that'll help the regulators. Once if they've mapped things correctly, that if enterprise A goes into distress, they know right away they better get a team on enterprises C, D, and G. So again, whether folks can really operate this thing as it's intended is anybody's guess, but it certainly is impressive in terms of putting together a plan. Information systems, it's all the portal. Contact information. I guess at least the last note, what's the process? Again, it is an iterative process. You really should be reaching out to the financial institutions, to the regulators now to help you work through it. Within 60 days of your submission, the Federal Reserve Board and the FDIC must provide notice of any missing information if the materials are deficient in any way. You'll then have 30 days of receipt of that notice to provide any missing information. Once the plan is determined to be informationally complete, the Federal Reserve Board and the FDIC are jointly going to determine whether the plan really does meet the goal of rapid resolution of the enterprise under the applicable regimes. If there's a deficiency there, you've got 90 days to respond to that. And what happens if you don't? Well, the punishment for failure to cure deficiencies within that 90 days, they're all discretionary. They include subjecting the company to more stringent capital, leverage, or liquidity requirements, or restrictions on growth activities or operations, nothing that any enterprise wants to have to confront, especially because they failed to provide a report properly. That's a difficult discussion, both externally and internally, I think. In extreme cases, there could be forced divestiture of assets. Again, that really, they do give folks an awful lot of time to kind of comply. It's basically 2 years built into not addressing your deficiencies. So hopefully we don't see anything in the line of forced divestitures going forward. I think that's all I had, unless any other questions.
I don't know if there, as always, there's so much content to some of these things that the time can never do justice to all the issues that might arise. I don't know, Kathy, were there any questions rolled in?
No, we don't have any questions from the webinar. Obviously, the last slide has everybody's names and contact info. So.
Yeah, I mean, we're certainly available to respond. Many of you, I'm sure, have already looked at a lot of this. This is, in a way, is a summary and overview of stuff that the industry, particularly the foreign banking community, more recently has been looking at and thinking through. There's still some time to think about it, but not as much as there was. And we're certainly available if we can help answer specific questions or deal with any particular issues. So we thank everyone for attending in person and online, and hope to see you again soon. Thanks again.
Thanks.
Today is our program on prudential standards and living wills under the Dodd-Frank Act. Our particular focus will be on the applicability to foreign banking organizations, and my colleagues, who I'll introduce in a moment, will really carry the major load and have most of the knowledge to convey. Just a minor housekeeping item, since we are both live with people in the room and on the on the web. The web participants should have a chat feature within the WebEx tool that will allow you to ask questions. We may not be able to get to everyone's question. Don't be deterred. Please send your question through anyway. And we can certainly speak offline after the program, or you could, of course, contact any of us directly. Contact information is in the materials that you should all have. Lines will be muted on your end, but if you need assistance, just press *0, and a coordinator from our staff will be happy to jump on. The event is being recorded, and we typically post it to the Arnold & Porter website, where it will be available to the public. Shortly after the program, we'll also post all the presentation materials that have been used. So again, thank you very much for coming, and why don't we start in. I'm Kevin Barnard. I'm a partner in the Banking and Financial Institutions practice based here in New York for A&P. To my immediate right is Dave Freeman, who heads our practice in that area. Dave is based in Washington, but thankfully is periodically in New York, and we hope comes more often to New York. I should say everyone's bio and detailed information is in the materials, so we won't go through that in any detail. Today's foreign bank release, including the requirement for specific resolution plans for the organizations, which you'll hear described, the more systemically important organizations that were the focus of these rulemakings. Rather than go in any real detail through slides that are in the book, they are picked up in one way or another in David, Evan, or Kathy's presentation. And since we want to focus particularly on foreign banking organizations, I think the best way to get into some of the details of who's covered by these proposed rules at an operational level, what might they mean to deal with some of these requirements, I think is probably best handled as we hand off from one to another. I think in the order that the materials appear in the book, probably Kathy should take it from here, and then we'll just follow the order that we have in the materials. Kathy?
Can I borrow the clicker? Thanks, Kevin. As you said, I'm going to focus on the proposed enhanced standards and early remediation, or proposed standards for the foreign banks in the U.S. And it's in many ways similar to what is in the proposals for the domestic banks. In the preamble to the proposed rule, the Fed, though, makes the point that even though the proposals for the domestic banks are still outstanding, to the extent that there are some differences in the foreign bank proposed Prudential standards, that people should not get the notion that that's what they're thinking about doing for the domestics. So sort of everything is sort of still a little up in the air. But the notice of proposed rulemaking was published on December 28th, and the original deadline for...
His immediate right is Evan Hollander, who's a partner in our bankruptcy and restructuring practice. We are in a period, and this is a topic where the need for people with Evan's skills may become more evident as time plays out. So we welcome Evan to our group. And Kathy Scott, to Evan's immediate right, is also in our banking and financial institutions practice, has had a career both as a regulator and in private practice, has had a particular focus on work for foreign banking organizations, and I think among all of us, at least on the A&P team today, is the person who has actually been involved in resolving and liquidating one or more U.S. offices of a foreign banking organization. So a skill that we hope no one on the call today has any need to call on anytime soon, but it is there if needed. What I'm going to do is just give some introductory remarks as to how the Prudential standards and living will requirement came in. We're still in a period where, as with so much of the Dodd-Frank rulemaking, final rules are still not in place in most cases. The two particular sections of Dodd-Frank that we're most concerned with started out clearly with a domestic focus, and Federal Reserve and the other agencies, but the Fed is in the lead here, came out with a proposed rulemaking in January of 2012, which really focuses on the domestic organizations. They specifically mentioned that because of issues that needed additional review and analysis, the applicability of enhanced prudential standards and resolution plan or living will requirements for foreign banking organizations, credit limits, particularly for large counterparties, large organizations dealing with other large organizations, stress test requirements, which is the one area where rules have been advanced and finalized, and in certain cases, limits on debt to equity ratios and funding. The general, I think, rubric that this fits under is an attempt to deal with organizations that were thought to be so important to the financial system that if they experienced the kind of turmoil and stress that was seen in the 2008-2009 period, we could once again have a crisis mode environment calling on extraordinary measures from the government and ultimately extraordinary support from taxpayers. In the midst of the debate on these issues, which of course are not limited to the U.S., it was recognized that in the U.S. we have both the large U.S. banks that operate globally and large foreign banking organizations, and in many cases non-bank financial institutions that operate on a global platform and are key participants in the markets in any number of jurisdictions, and certainly almost all participate actively in the U.S. In July of 2011, the Financial Stability Board, one of the several sort of College of Cardinals organizations of principal supervisors from the developed countries, issued a consultative paper. So this preceded the Fed-driven rulemaking that came out in January of 2012, and a number of the provisions in that or suggestions in that consultative paper came to be picked up in the Fed release, and then subsequently in the more focused would be dealt with in a further rulemaking, which then did emerge several months later. Both the January 2012 rulemaking and the subsequent rulemaking for foreign banking organizations have not been finalized. And in fact, the key provisions applicable to foreign banking organizations are still open for comment. The comment period has been extended twice now. Very briefly, the context from which a lot of this emerged, of course, was the turmoil of 2008 and 2009, a sense that large, complex organizations, many of them traditional banking organizations, but certainly not all of them, presented a risk to the financial system, both in the U.S. and globally, which was either poorly understood or at least poorly tracked and regulated by the existing supervisory tools that were in place, and that something else was needed. Like so much of the Dodd-Frank Act, some very broad requirements were put in place, but a great deal was left to regulatory rulemaking and adoption. Again, that's still the period that we're largely in. One, focusing just again for the moment on the domestic organizations, but this is largely carried forward, as you'll hear, to the foreign banking organizations. Federal Reserve was mandated to issue rules for enhanced standards in a number of areas, and I won't go through slides in any particular detail, but they hit all of the key areas involving capital, liquidity, risk management, including in some cases establishment of risk committees within an organization with a particular mandate and charge.